Welcome back, everybody, to Event Tech Live USA Canada 21 and to the main stage and our next session. The implications of EU GDPR and UK GDPR has on event tech businesses in North America. More relevant than ever, I feel, and I'm delighted to welcome Chief Event Technologist at Smart Tech Business Solutions, Avi Verdi. Avi, welcome to Event Tech Live.
James, thank you very much. Pleasure to be here.
It's, as I said, a topic that has more relevance than ever, I feel, given how many virtual events, given how many hybrid events, and given how wide audiences can now cast their net, or organisers can cast their net with their event audiences. I'm going to hand over to you, but please don't forget to the watching audience that if you want to post your questions for Avi about this subject, please do so in the Glisser Q&A function underneath the video window, and I'll be back a little bit later on with those questions for Avi. But for now, over to you.
Great, thanks very much, James. Okay, so the title of this presentation is a bit of a mouthful, but it is, as James says, a fairly important subject, albeit a dry one, so can't really get away from that. And although it talks about event tech business, this presentation is really about event businesses as a whole. Most of the audience here, I think, would be based in North America, not just technology businesses, but event businesses. And of course, events and data go together quite a bit. But first, just very briefly about Smart Tech Business Solutions, who we are, what we do, in operation since 2013, very much independent and focusing on both technology and data solutions for the meetings and events industry, rather than having our own products to push. Basically focus on two areas. One is data protection, in particular GDPR solutions for businesses, and that's not just in the UK, that's globally. But also virtual and hybrid event solutions. So virtual was the events word of the year last year, and hybrid is the word of the year this year. So we've jumped on the bandwagon as well. So we have a service called hybrideventsolutions.com. But coming back to GDPR, firstly, just a disclaimer. Everything you're going to see here is obviously advice, shouldn't be seen as legal advice. Please speak to a legal professional if you need to. Okay, so GDPR, the General Data Protection Regulation. Just a brief recap. So this session is not really about going into it in great detail, but more talk at a bit more of a high level, because I'm sure most of my audience now are, well, they must be experts in data protection, because they've had, 5 years since GDPR was approved. It came into effect 3 years ago, and what it spoke about was the principles of the protection of personal data, distinct from data security and cyber security and people stealing credit card details. This is more about our data, our personal data, which we have on so many social media, so many other places as well, or in the events industry. We give our personal data to events companies, and what do they do with it? We want to make sure that they handle or process that data in a correct way. It applies to any company which is offering goods and services to individuals in the EU. So that covers the range, the reach is extraterritorial. So it includes all companies around the world, including obviously North America as well. So anyone who either offers goods or services or just even holds data. So holding data is, you might be offering some sort of a service where you need to offer services, or just holding data like a database service, etc., where you have EU citizens' data. So one of the key things which came out of GDPR when it all came about were the fines, the eye-watering fines for lack of compliance. Just notice an interesting typo there. That's not 20 euros, it's 20 million euros. So, or 4% of an annual global turnover. So that was a big stick that was used. Um, just talking again at a high level, just on the main principles of GDPR. Firstly, it's about personal information or personal data, anything which can identify you as an individual. There are four, or rather six, key principles for data protection, and that is security, the lawfulness of processing, and transparency. So the key aspect of data protection is if you have personal data, you must use it in a compliant way, and you must have a legal basis for processing that data. And I'll just talk about the main legal processes in a second. You should only keep a minimal amount of data, only the data you need. You should only use it for the purposes for which you got the data in the first place. It must be accurate, and you must have a retention policy, which means when you don't need it anymore, you must delete it. So really, very much the thing to take away is less is more when it comes to data. Key aspects, there are six legal processes for a legal basis for processing data. The key one for us in the events industry are firstly a contract. So I would say that in most cases when we do events, we capture personal data for people, and that is a contract we have with them. Another aspect is a legitimate interest. So we process based on legitimate interest. And the third main one is consent. So I don't want people to get hung up on consent. So when GDPR came around, most people did get hung up on consent and just try to think in terms of consent, whereas consent is only one of six legal bases. And in our industry, mostly I would say contract and legitimate interest are far more relevant than consent. The other three legal bases are more broad, so less so for our industry. At the same time, all individuals now have a access, or they have rights to their personal data, so they have 8 rights. Another key area is international transfers can only take place with legitimate what are called safeguards. So that is a transfer of personal data, of EU personal data between borders. The reach of GDPR is global, and that means that companies need to appoint an EU representative. And ultimately, companies need to be accountable for their data. So in this talk, I'm going to concentrate on those last two: the global reach of the GDPR and the need to appoint a representative, as well as the transfers of data internationally. Okay, so what does GDPR mean for North American companies? It applies to any companies which is not just selling or is even offering any products or services, or even it's like a website which is accessible in North America, which can collect the data of EU citizens, even though that might be via cookies. So you would be asked to, you would be compliant with, need to be compliant with GDPR. It applies for companies in the US or in Europe who have partners in North America. There was, as GDPR came along, there was many US companies were thinking about segmenting their data and keeping EU data separate from the rest of their data. In other words, treating EU data with a certain level of compliance, and the rest of the data just treating as they did before. But ultimately, it wasn't worth the hassle. And also, since GDPR has come along, there have been a couple of North American-based regulations, although PIPEDA was there before GDPR. They are different. So I will briefly talk about PIPEDA and CCPA. And also, if you're a company who are ISO 27001 certified, it doesn't mean you're complied with GDPR. So GDPR is separate to all of those. Just looking at events and the global nature of events. So I just want to stress this. A couple of aspects. One is the global nature, obviously. The other is the type of companies involved within our industry. And the other is the exchange of personal data and the type of personal data. So we all know that anyone in events, we all travel to events, people travel to our events from all over the world. We hold their information. So not only do we have their personal data, but we also are, in most cases, transferring data from one company to another. So it might be a corporate events team working with an agency, working with venues, hotels, etc. And look at those different types of data, starting with an invitation list, an A&D list, a transfer list, etc. So many different types of personal data within our industry. And this diagram is what I call the events supply chain. Again, we're looking at the transfer of data from an event owner, possibly to an agency. So that might be like an invitation list. From the agency to a supplier, might be a rooming list. A supplier might use a third-party partner, so an activity list. So just these people are going to take part in a golfing golf tournament, and then data coming back the other way as well. So we know, and all the way back to the original event owner, who wants to see a registration list, a participation list, etc., as well as other data and details about the attendees. Okay, so there's a lot of data, and it's been transferred across a lot of different places. So I just want to talk briefly about one of the aspects which will affect most North American companies, and that is the need to appoint an EU representative. I'm kind of hoping that you've been through this before, so many organizations would already have been through this and already have appointed a representative, which can be any individual established within the EU. And it's basically a representative required of any business outside the EU, so let's talk about in North America, which does not have an office in the EU, or a representative in the EU, and yet regularly processes the data of EU citizens. Okay, so most event companies based in North America, they don't have a branch or representative, or don't have a branch or office in the EU. They would be required to appoint a representative, and those are some of the services a representative provides. One classic example is something that happened to me. I registered for a SaaS service which was actually based in the US, and after I registered, I saw that the password which I submitted became my username. So I thought, this doesn't sound right. I contacted that company. I never heard back from them. So I decided it's better not to use that company at all. So I kept away from them. That's where basically, if the company was reputable, they would have an EU representative. So I could then contact that EU representative and say, listen, I've got a query about my data. Please, can you assist me? And then find remediation. As it is, I'd rather not deal with that company at all, because I don't feel that they process my data in the correct way. Okay, so I've just talked about a few basics about the GDPR and the representative and the principles. I want to talk now about Brexit, which happened at the beginning of this year. And the key thing is this, right? Before the beginning of this year, there was one GDPR, which applied to all individuals in the EU, which included, obviously, individuals. Sorry for the clunky wording, but that is wording of GDPR. It included people or individuals within both the UK and the rest of the EU. Since the beginning of this year, there have been the UK officially and finally left the European Union. And what the UK did was it absorbed GDPR principles into UK law. So now, as of the beginning of this year, there are not one but two GDPR regulations that companies around the world have to follow, have to comply with. Okay, as long as they are processing the data of both EU citizens and UK citizens. Again, I'm going to be talk generally. In the events industry, we deal with large volumes of data from people all over the world. So I'm just going to make the punt that most people watching here are in the events industry, so they will be impacted by this. Okay, so there are now two GDPRs that you need to comply with. Now, one of the outcomes of this is the fact that just focusing on one of the areas I started off originally is the representative requirement. Okay, so first new thing is that UK companies need to appoint a representative in the EU and vice versa. That's new. That doesn't affect North American companies. What does affect North American companies is that whereas before they did require an EU representative, now they require two. Okay, as long as, again, that proviso, they don't have a branch or office in either the UK or the EU, and they process the data of both EU citizens and UK citizens. All right. So if you've had one representative, you may now need to appoint another in the UK. So that's one area of change. So just looking at why you should appoint a representative, well, basically it's a law. Okay, so to be compliant, there are fines involved. Now, I fully understand that I should have sort of like preface this whole discussion about this dry subject is that obviously we've all had other things on our minds for the last year and a half. So data protection and managing data hasn't been one of them. And obviously there have been very few events. But as the events start to pick up again, this is an area that all event companies just need to start addressing again now. So data compliance, and hopefully this is useful knowledge now that you do realize that as events pick up, you do process a lot of data of people all over the world, and you now need to start thinking about compliance again. So that's the first aspect, the need for a representative in both the UK and EU, and the potential of fines if you don't meet that as business picks up again. So the other area I want to talk about is the transfer of data between the UK, EU, and North America. So looking at Canada first, currently there is a PIPEDA is a privacy policy already in place in Canada, which applies to not all companies. Yeah, it applies for personal data, which is used for commercial use only, and there is some crossover, but GDPR is far more broad-ranging. Okay, far more broader. And basically, if you're covered by PIPEDA, then you are covered by GDPR. However, if you're not covered by PIPEDA, then you have to go through a certain process, which I'll explain in a second. In the US, there was the Privacy Shield, that companies which were covered by the Privacy Shield did not have to go through certain hoops, but that was invalidated last year. And as a result, US companies have to look for an alternative safeguard, as they call it, which is standard contractual clauses. And I'll talk about that in a second. So let's just look at the transfer of personal data between the EU and North America. So between Canadian companies and the EU, they can continue to use the adequacy decision provided they are covered by PIPEDA, or the Canadian company is compliant with PIPEDA. Otherwise, they need to use standard contractual clauses. And that is for two-way transfer, not just for one-way transfer. For US companies, they have to use standard contractual clauses. So hopefully, US companies are actually used to using standard contractual clauses when dealing with EU companies. Now, I understand a lot of this may sound very technical. there's only so much detail I can go into at this moment, but I'm kind of hoping that you do understand standard contractual clauses. These are actually off-the-shelf documents which have been created by the EU, which you need to use when transferring data between the UK, EU, and anywhere abroad. Okay, anywhere overseas. So just looking at that's EU data. If we now look at UK data, it's exactly the same principle. So just like you need to now appoint a second representative, one in the UK and one in the EU, when it comes to transferring personal data between both the EU and the US or North America, as well as the UK and North America, you need to have separate arrangements in place. Okay. In many cases, those will be standard contractual clauses. So really, on your side, there is quite a lot more admin work which you need to be aware of, simply because the UK and the EU are no longer part of the same single market. Okay, so let me just look at some other areas that you need to consider as well. So the supervisory authorities, all EU countries have their own supervisory authority, and that is an authority which looks after all the personal data and data protection regulation within that country. Now, each country has their own. The UK has its own, and it's called the ICO. Basically, what happened before is that if there was a breach of data or anything along those lines, any company which needed any remediation could just go to one supervisory authority, and they would then handle all of the claims and all the requirements. Yeah. Unfortunately, the UK now, because it's no longer part of the EU, is no longer a part of what was called a one-stop shop. So the UK is no longer a member of the club, so to speak, which means that there are implications for businesses in that now, if you're a company in North America and you have a data breach, and that breach includes the data of both UK citizens as well as EU citizens, then there is the potential for you to face fines from both sets of authorities. Okay, so that there is another aspect that you just need to think about. So another thing to be concerned about now that the UK is out of the EU. So both have very similar and almost parallel rules and regulations, but it is a consideration for you to have to comply to both. Okay, so other changes following Brexit. Now these are, so I've covered the main changes, the main ones which I wanted to cover, and I think I'm a bit ahead of time, so I should be able to give you a bit of time back. So if you have any questions, please put those in, and I'll pick those up with James shortly. But the last couple of slides, the last couple of things just to note to go through is your privacy notices. Most of you have those on your website, or it's either a privacy notice or a privacy policy. It's very useful if you can review those and just refer to the fact that you're cognizant that now there are actually two different GDPRs. You probably went through a process 3 years ago to update your privacy notices, but it'll be wise to update them and make reference to both GDPRs, because what's going to happen is when companies in the UK and EU, if they're looking for suppliers in North America, they want to make sure that those suppliers are compliant with data protection regulation and are aware of their obligations. So that is something that would be wise for North American companies just to review their privacy notices and update them in accordance with the new regulations. Similarly, you may have a documentation, existing documentation, which refers to GDPR. Again, it may have been forced upon you, but it is something that you now should review and separate. And it may require that you need to keep two sets of records, one for your the data you hold on UK citizens, and one for data you hold for EU citizens. And that could be contracts. You may carry out data protection impact analyses, or you may have a data protection agreement in place. And also, you may, depending on the size of your company, you may have a data protection officer or a steward. Again, one of the changes is that because now there are two GDPRs, you may have to appoint, you can want a separate one for your EU data and a separate one for your UK data, although you can appoint the same person, the same physical person, because the laws are so similar that the same person could actually look after both sets of data. But again, in terms of what's required at your end and the admin required, you just need to think in terms of the two regulations that you now need to comply by. Okay, and that's really what I wanted to cover. So those are the main areas. Smart Tech Business Solutions. I know this is a very dry area, and a lot of people, there's a lot of words in data protection, especially GDPR, which people have great difficulty in really comprehending. But we offer free consultancy, and we're happy to just have a discussion wherever you are on your data protection journey. If you're not sure exactly what the requirements are of you, then happy for you to get in contact with me directly or the company. There's our websites there, and we can then happily just have a chat with you, find out where you are, and see if we can help you further. Okay, so I'm hoping James is ready. There he is. So James, I don't know if you have many or any questions, and I'm happy to field any.
Absolutely. Thank you very much, Avi, first of all, for joining Event Tech Live today. I'm going to run through a couple of very, very quick questions, if I will, but I do have a suggestion. Because this is such a complex area, I feel that everybody's circumstances will be quite unique. Each individual organizer or operator or supplier will have perhaps their own unique set of circumstances and challenges that maybe one answer doesn't fit all. What I'm first of all going to suggest is that within the Event Tech Live platform, you find Avi's details, and any of our watchers who are tuning into this session today, if you do have specific questions, connect with Avi through the platform. And Avi, if you would do the same, if you would reciprocate those invitations to connect, and then any specific questions can be directed in that manner. And I feel for this particular topic, that might be a very, very good course of action. What I would like to ask very quickly is two things. Realistically, and this is a bit of a blunt question, but I'm sure one that people are thinking themselves, realistically, how difficult will it be to enforce transatlantic contraventions in data privacy?
I think realistically, everyone's got, well, I mean, that question came about initially before we had the pandemic. Okay, and it was a very hard one to answer because the whole regulation was brand new, and the whole question was how could you actually police it. So the reality was it was going to be very difficult to police, especially companies in the US. That there was another aspect, and that is that companies in the US ran the risk of losing business because companies in the EU would be looking for suppliers who met those regulations. So there was an onus on them to actually meet those regulations. So the way to answer your question is basically very difficult, either pre-pandemic or post-pandemic, but there is an incentive that potentially you won't win the business if you're in North America and you don't comply with the regulations.
And like any law, anybody can choose to flout a law in any country of the world, but it then becomes an ethical question, doesn't it, as to whether or not you abide by that. If I can turn to one final question, and it relates to the subject of requiring an EU representative. I was just curious to know whether or not that presents freelance opportunities for event professionals, perhaps within the EU and the UK, to effectively set themselves up as EU representatives if they are registered with places like the Information Commissioner's Office, and whether or not they can then act as that representative on behalf of American organisers.
Well, officially, a representative can be an individual. So the answer to your question is technically yes, anyone can be a representative. However, the representative is also liable in case the company defaults. Yeah. So on the one side, it might seem like a great opportunity. On the other side, it's a great risk as well. So my advice to North American organizations would be to look for a service company, obviously a service we provide, a reputable company which obviously knows the industry and knows data protection and is obviously capable of supporting you in case of a default. However tempting it might be to appoint a family member or a friend, so that's something just to be wary of as well.
Absolutely, and of course having that level of indemnity built in that comes with using a reputable organisation. As I said, a lot of both of those questions that I asked you are relevant to what I said when I came back on screen a few minutes ago, which is that it's very unique to a person's individual circumstances and to an event organizer's individual circumstances. So please do go into the Event Tech Live platform, search for Avi Verdi in there. You can make that connection. And if you do have specific questions that you would like to put to him after this session has ended, please do so using that platform. It's been great to have you here, and it's been a very, very relevant discussion given everything that's happening in the event world at the moment, the amount of data that is flowing backwards and forwards transatlantically. Avi, thank you very much for joining Event Tech Live today.
Thanks for having me. Thank you, James.